Curious about divorce laws in Washington? Here are 12 that might surprise you. Stay tuned until the end. We truly do have some surprises.
Surprise!
Careful, you could hurt somebody, like me. The first surprising law: adultery really doesn't matter when determining who should receive custody of the children, who would be paying or receiving maintenance, sometimes called spousal support, and who would receive what portion of the community's property. Washington is a no-fault state. Many litigants who don't have an experienced attorney get caught off guard by this. They commonly bring up the other side's infidelity when trying to argue for various types of relief in court. Unfortunately for them, this tends to upset the judge rather than help them. Surprising divorce law number 2. Whoever has the kids most during separation usually wins custody. If the parties informally separate before receiving a court-ordered parenting plan, whoever had the children most during that informal separation will almost certainly win primary care of the children. This often applies when a chivalrous husband decides to move out of the home as the parties begin to break up. Being the chivalrous one, he leaves the children in the family home with the wife when he moves out. The court will often assume that this period of informal separation speaks louder than anyone's words in a subsequent hearing or trial. The person who has the children most during the separation, the mom in this instance, would almost certainly end up winning custody of the children in a custody battle. Surprising law number 3. The court will usually treat pets as property rather than doing a custody analysis. Now, that may seem wrong to many people who have pets because pets are often emotionally akin to our children. If you'd like to learn about the basics of Washington's property division laws, we have an article on the subject. We also have a much more in-depth article on community property laws in Washington. Surprising law number 4. Do not throw that. Thank you.
Sorry.
Surprising law number 4. Evading service of process isn't against any rules or laws. In other words, if someone is trying to serve divorce papers upon the other spouse, it's okay for the spouse who's being served to try to hide or run away or otherwise avoid being served with those divorce documents. There's no rule saying that you can't try to avoid initial service of process. That said, you might not look good in the court's eyes if you're evading service of process, and chances are you'll eventually get served anyway. Our firm advises clients to simply cooperate. Surprising divorce law number 5. You can trick someone to serve him or her with documents in a case. Let's say you want to serve someone who isn't opening the door, or maybe the person is trying to hide in a different state or community. You can use trickery to make the person answer the door or admit where they are. There's an especially common trick employed by professional process servers. They will go to the location of the person who is to be served and pretend to be delivering a parcel, maybe for Amazon or some other delivery service. Usually the process server has a box wrapped just like something that's being sent in the mail, and they'll say that they have a delivery. When the person who's to be served opens the door, they serve the legal documents. A word of warning: if you're going to serve someone through trickery, do not impersonate a police officer or a fireman. That would be illegal. Surprising law number 6. Washington will divorce people married by common law. Washington will recognize common law marriage in some instances. For those who aren't aware, common law marriage is when parties live together like a married couple for a very long time, and the rules of the state will treat them as if they are married, even if they never went through the actual marriage process. Washington is not a common law marriage state, but Washington will recognize a common law marriage that occurred in a common law marriage state. For instance, let's assume parties live together like a married couple for 20 years in Montana, which is a common law marriage state. Washington would recognize that couple as being married for purposes of getting a divorce in Washington. If, however, the parties were living together like a married couple in Washington for those 20 years, they would not be treated as common law married. Surprise number 7. Washington has a corollary to common law marriage. If a couple lives in Washington for years as if they were married, we deem them to have a committed, intimate relationship. Washington will allow them to dissolve their relationship and divide their property almost as if the parties had been married. There is a significant difference between a regular divorce and a committed, intimate relationship that's being dissolved. The large difference is spousal maintenance, sometimes called alimony. Judges in Washington will not award maintenance in the case of a dissolution of a committed, intimate relationship. Surprising law or fact number 8. It takes almost a full year for the average person to get divorced in Washington state. It's a long process, a lot longer than most people think. Surprising law number 9. The fastest a person can get divorced in Washington is 91 days. Even if the parties agree to get divorced and agree on all the aspects of the divorce, such as who gets the kids when and who gets what property items, how much child support should be, etc., Washington will not allow them to get divorced any faster than 91 days. Washington has what's called a 90-day cooling off period to make sure the parties truly do want to get divorced. Surprising law number 10. You can essentially get divorced in Washington almost immediately without having to wait for the 90-day cooling off period to pass. And that is if you call your divorce a legal separation. You can get a legal separation often the same day that you petition. Surprising law number 11. In Washington, a legal separation is essentially the same as a divorce. It's just a difference in terminology for most intents and purposes. Now, there are some differences, and some can be big for some people. For example, if you have a legal separation, you can't get married to someone until you convert that legal separation to a divorce. But for most other purposes, a divorce and a legal separation are the same. So the very same set of laws, the very same set of procedures that you have to go through, the very same kind of trial that would be at the end of the case, and you get the very same kinds of documents. You get a decree, you can get alimony, spousal support, child support, division of all the parties' properties, etc. If you'd like to learn more about the differences between legal separation and divorce, we have an article on the subject. The 12th and final surprising law on our list, Washington allows the courts to impute a party who is voluntarily unemployed or underemployed for purposes of child support, maintenance calculations, and property division. What imputation means is that the court is treating a party as if he or she has income, even when the party doesn't have that income. The most common example of imputation is if someone really does not want to pay child support to the other side and quits his or her job to make it look as if he or she is penniless and unable to pay child support. The court will usually deem that party as having the income that he or she would have had she not quit or reduced his or her hours. Now that you've heard about imputation, you might say it makes perfect sense, but there are some very surprising ways that the courts have applied this rule. For example, the courts have said that if a person goes back to school to get a degree, that person should be imputed, even if he or she is doing it for purposes of making a better life for him or herself, or to better the child's life in the near future. Another interesting imputation example, the court has said that if a party voluntarily reduces his or her hours in order to care for the children at home, he or she should still be imputed. So that's it, all 12 of the surprising laws on our list. If you would like to read the article on the very same topic, you can do so by going to the following web address. We also have numerous articles, guides, and videos on our website regarding virtually every topic you can think of pertaining to divorce and family law. I would encourage you to go to the resources section of our website.